everyone. Thank you for being here. My name is Callie, and I am the Communications Manager for the ECAC, and I have the honor of introducing Stuart Discount, our ECAC's chair. I did want to let everybody know that this is recorded, and we will share this after. But as for right now, take it away, Stuart.
Thanks, Kelly, and thank you, everybody. Welcome to the first of many webinars that the Enterprise Communications Advocacy Coalition will be sponsoring. Welcome to our member partners, and welcome to those who maybe are hearing about the ECAC for the first time and are joining us. For those of you who may be hearing about us for the first time, the ECA was founded several years ago by past leaders of the ATA PACE Government Affairs Leadership Team. Our mission is to advocate for and educate Congress and the regulatory organizations on issues that affect contact center operations and enterprise customer communications. Some of the issues that we plan on tackling and already have include privacy, TSR, TCPA, AI, and consent. With PACE closing its doors, there is a need for a nonprofit coalition of companies to become the voice of the contact center industry. That promotes our needs at the same time promoting ethical and legal communications with an eye on providing excellent customer interactions. Today's webinar is the first of many, as ECAC will have monthly webinars on focused topics that are important to our member partners. Many of our member partners possess subject matter experts, and most of the future panelists will come from those partners. All of our panelists today are member partners. We urge all of you who are not members to consider joining ECAC and contribute to our policy positions, because many of you feel the operational financial brunt of negotiations. Collective opinions and positions are essential in making sure when we go to Congress or the regulatory agencies, we are delivering the correct message. Our dues are $4,000 annually, and that entitles your firm to have several team members participate at no cost when attending webinars, alerts, posting blogs, and be potential webinar participants. You will certainly hear from us after this webinar, but you can contact us by going to our website at www.ecacusa.org. Before we get to today's panelists, I wanted to first urge you also to go to the ECAC LinkedIn page and share it, and we'll have a lot of postings on there. Our next two webinars are in place, as you can see. Callie, did you move up the slide on that? Yes, you did. Our next two webinars are in place, and as you can see, you can register for the October event by using the QR code there. This webinar will be the first in a two-part series that will take a look from two experienced lobbyists in real time what is happening during this election thing. That will be followed up in 2025 by how the results of the elections will affect the contact center industry. This will be a fun webinar in October, and I hope you can join. If you have questions during the presentation, please ask them in the chat area. We hope to get to some at the end, but if not, we will ask our panelists for some help in providing answers post-webinar. All attendees will receive a recording of today's webinar, as well as the answers to those questions. I now have the privilege of introducing our panelists, who are no strangers to the contact center community. We will have a conversation on legal telemarketing and how regulations and technology will continue to affect the channel. Joe Bowser is a partner at Roth Jackson, who is a longtime legal expert on TCPA, TSR, and other contact-centric matters. Manu, director of eTech Insights, and I'm only using Manu because I can't pronounce his last name, and he wants to be a soccer star, so we're going to go with Manu, is a pioneer in leveraging AI and machine learning to revolutionize customer experiences. With over a decade of experience, Manu specializes in developing and implementing conversational AI, speech analytics, and process optimization solutions for contact centers. Jim Ayu was supposed to be also from eTech on the panel. Jim is at a conference, and unfortunately he's in Florida, where he's stuck in the hurricane, unfortunately. But thanks for Manu for stepping in. Also, we have Isaac Sloss, Chief Product Officer at Contact Center Compliance, also a well-known contact center IT and technology expert and speaker. So with that, welcome, gentlemen. And I'm going to go to the first question, and that is going to be for Manu. Manu, one of our focuses is on AI. So, with your experience, I really want to get into a couple of questions. And again, Joe and Isaac, please feel to jump in. So, how are AI and advanced analytics changing the landscape of compliance management in contact centers?
That's a great question, Stuart. And before I go there, thank you so much for having me here. This is a privilege. As far as AI in contact center is concerned, when you think about it, especially recently, when you think about language models, they are built to be able to manage language. And that's exactly what contact centers deal with every day in and out. Now you are able to scale that up to be able to analyze every conversation that your agents are having with customers. So you are able to analyze conversations in real time, understand if compliance are being met. You're also able to educate your people better. Because when you think about it, AI regulations have been a little bit of shifting goalposts, right? Something or the other changes, you have to stay on top of it. And not just you, but you have to ensure everybody in your organization is current. And that's where AI can come in. Using simulation training can help you train everybody very, very quickly. And of course, you can also use it to manage consent, ensure there are clear consent indicators that are telling customers exactly what you'll be doing. So those are some things that AI is doing currently to ensure that you're able to manage compliance better in contact centers.
So continuing on, one of the top, one of the concerns and one of the things that ECAC is doing is, what kind of legislation, what are we going to see? What is, Congress or the regulatory bodies going to, attempt to try to regulate the use of AI in contact centers? So do you have any insight on that?
We will see regulations around specific how the models are being trained, what are some ethics and bias, and ensuring that the AI models are transparent. We will also see robocalls or AI generated conversation requiring pre-consent based on what we are seeing. But yes, regulations are coming, and I think as the AI technology evolves much more, we will see some of these regulations being implemented soon.
Joe or Isaac, do you have any, Joe, from the legal expert, have you seen anything yet when it comes to AI?
Well, sure. So as soon as that New Hampshire Attorney General incident occurred early this year, the FCC at record speed declared that AI-generated robocalls are a pre-recorded call for purposes of 227B of the TCPA, the first subsection of the TCPA, substantive subsection. So any AI-generated voice is now treated as a pre-recorded piece of content. And the FCC has published an NOI and a notice of proposed rulemaking to ratchet up the AI rules. So for example, the current further notice of proposed rulemaking includes both the definition of pre-recorded calls to include AI. It includes disclosure obligations so that if you make a pre-recorded call, like an AI-generated call, you have to not only say, who's calling and give the identification requirements, but you also have to say that it includes AI-generated content, and you have to get in your consent form explicit permission to use that kind of content. So it's going to further modify the prior express written consent requirements to make those types of calls, assuming, of course, that form of NPRM gets issued in the future.
The ECAC will be filing comments. And I think that's by the middle of October, we have to have those comments in, and we're going, and our partners are able to chime in prior to that with their opinions of how operationally, if this will affect them at all, because some of that consent is already needed anyway in the pre-recording.
Right.
So
it's really not. They do take a fairly hands-off approach to AI on the inbound leg of the call. So there is a little more room to play on the inbound side of traffic, for whatever that's worth.
Okay.
But that, that is something they are looking at changing. They are looking at the inbound side. I think specifically addressing customer service as the first point of concern. And I've seen that in some of the discussions and in some of the NPRMs, I've seen references to the inbound customer service and specifically calling that out. I know a lot of us have already been holding for a while, hey, just treat AI as pre-recorded artificial voice. So whether you're looking at the TSR or the TCPA, just treat all of it as that pre-recorded voice and make sure you're getting that proper consent. And I think that with the disclosures or the watermarking or the indications that they're talking about putting now specifically on outbound, that's where it's going to get really interesting. And I think where the comments have to be really thought through on that because, I saw a question on this, so I'll just go ahead and address this now. This was my first concern. Is that going to be at the beginning of the call? You would think that's where it needs to be. And then you start thinking of some of the states' more onerous disclosure requirements like New Jersey, where there's a slew of things you have to spout out in the first 10 seconds. This just adds to the pile. However, we have to be careful as an industry in our pushback because I spent a lot of time last week with people from enforcement and regulatory in DC last week. And one of their concerns is that no one's trying to be a good actor. Everybody's trying to walk the line just barely or bend the rules to where they can say, well, that's kind of it. It's not clear enough. So, give some consideration because if we just push back and the industry just pushes back and says, oh, no, we don't want this. This is terrible. It's going to look like we're not even trying.
Yeah, Isaac, in our preliminary discussions on this topic, we've already that is really where we're coming from at that level. That and one of the tenets of ECAC is we don't want to be adversaries to the consumers. We want to be advocates for them as well as the industry. When something's reasonable. So that's point well taken.
Agreed. And Stuart, when you think about AI, it's not just AI conversations at the front end where end user is interacting with AI. It's also about downstream AI where you're taking these conversations and maybe analyzing them for quality or analyzing them for business insights. It has been made very clear, especially with some of the recent events, that you have to be very clear if you're using customers' voice or data to train your generalized AI models as well.
That's a really good point because a lot of lawsuits I've seen lately, like especially in California under SIPA, have been around privacy. I've seen lawsuits around a third party having access to data when that wasn't specifically consented to. So, we talked to, I know Manu, you're from a BPO. So when you work as an outsourcer, there are additional challenges potentially in where that data can be stored and how that relationship is. Because, as eTech operates as a BPO, a lot of times you're operating on behalf of your seller. So you have some certain relationships there, but under some of the state law, if you're working with anybody that has that, make sure the privacy is addressed, tightened up, make sure you understand where the data is being stored, how it's being used to train things, what it's being used to train. And, a lot of this is just where it comes down to having solid counsel that is familiar with all the appropriate regulations, not just, kind of general business law, but they specialize in this so they can help you craft policy so that you can continue to use these technologies in a legal way.
Yeah, before we go further, I was supposed to talk about, we are giving opinions here today, not legal advice. If there's concerns, you need to, speak to your own counsel. So just remember, this is just our information for you.
And a very brief soapbox to make sure that before you ask an agency to do something or not do something, and think about whether they even have the jurisdictional authority to do it in the first place. So agencies are not kind of self-executing legislative bodies. They get the authority they get from at the federal level, Congress, at the state level, from that state legislature. So we shouldn't all assume that, for inbound traffic, for example, the FCC has the same kind of authority it has for outbound traffic, right? So anyways, let's all, keep that in mind about who's given the marching orders here, right? Particularly in a post-Loper type world that we're living in now, where at least the Supreme Court thinks more seriously about the extent to which the agency actually has the authority it's using in the first place.
Very well taken. So Manu, let's continue on when it something on the compliance strategy. So, you know, companies still obviously, have an issue when it comes to compliance, with all the different regulations coming down. How's technology integration playing in trying to manage that strategy across contact systems?
That's a very good question, Stuart. And when you think about it, now you have to manage compliance from multiple fronts. It's not just about, that front end where you're trying to authenticate a customer or telling them, the recording statement should be there or robocall should be there. It's also data privacy. It's also data governance. It's also exactly how you are training your models. So what you will need in the end is a 360 view of your compliance strategy. And that's where AI can come in and help. You can integrate multiple systems across and have a single stream of insights when it comes to your aggregate compliance levels. Be able to see if your agents are compliant, be able to see if you're compliant from data perspective as well or authentication as well. So what AI can do for contact centers currently is ensure that you are provided with all the technological needs that you have to not do all of this manually specifically. For an example, you don't need to listen to calls to understand if I'm compliant or not anymore. And as Isaac was saying earlier, it's also about how you are storing your data, where you are storing your data, and who has access to it.
Right. Which also gets into the question of, that privacy of, what are the biggest challenges that contact centers have when it comes to that privacy that you're seeing?
Exactly. And yes. And when you think about it, let's say that I'm able to resolve most of the compliance regulatory knowledge or data challenges by having the best people in the world. I still have a challenge that I can't solve. That is, are my agents compliant on every call? And that's where AI comes in. Now you can listen to those conversations on scale. Ensure you know which calls were non-compliant. We also have real-time AI. If an agent misses to perform a step, it's gonna give a small nudge to the agent and inform them, hey, you missed to inform the customer about this. So AI is helping you implement compliance on scale and even train people on scale and ensure you are able to look holistically instead of few samples where you might miss something. And we all know even one miss is, just as bad.
Yeah, and
Yeah.
data. I'm sorry, Stuart. Go
No,
ahead.
get Isaac.
No, data storage of that voice recording or of any of that data you're pulling in is expanding your risk area or your surface area of attack. So this is where it's also important that if you are engaging these technologies, which can be very beneficial to your customers, to your development of your agents. So I'm not saying anything bad about it, but you just need to make sure you've got a solid plan. You need to make sure that you've got a strong IT department that understands how to build a secure environment, make sure it's being audited regularly, and again, make sure you have strong counsel that is guiding you to make sure that you are meeting all the legal requirements and kind of those two keeping each other in line.
Absolutely. And Isaac, that's an amazing point. And when you think about data storage of recordings specifically, you can minimize the risk drastically just by ensuring you only store redacted recordings. Let's not even increase the exposure by having recordings which has PCI, PII, HIPAA. Let's redact them. AI technology can help you do that. Only store redacted information and follow minimum data governance policies by ensuring you only store the least possible data that you absolutely need.
And if you're not keeping the recording, but you're keeping the transcription, there's not much of a difference there. If it's all,
Yes.
kind of that real time, it's in memory, it's transient data, and then it's just gone after that, I think that you definitely minimize risk there as well. But again, this is where you're going to need to rely on a strong IT department, a strong understanding of how the product works to make sure that it is truly cleaning things up afterwards. If you're one of the businesses, like I know eTech has been involved with this, with like PCI, where there are standards around data encryption, data storage, data in transit versus data in rest. Just make sure that whatever technology you're using fits into that type of framework. Even if you're not PCI certified, using the rules for PCI when it comes to that kind of thing can save you a lot of risk.
Absolutely.
Talking about risk, actually, and Joe, I want to bring you into this. As a contact center operator for me for many years, I was more not worried about the I wasn't doing anything illegal. I was, it's the class action lawsuits and the plaintiff's attorneys that you have to be more fearful of, because they're going after that little nitty gritty stuff, throwing enough stuff against the wall. So, Joe, how's 2024 been? What kind of TCPA litigation filings have been out there? What kind of cases, and where do you think it's headed?
So the fire hose has been steady, right? It's up slightly year over year. The latest data that we have is from July, and they are shifting. They continue to shift towards putative class cases. So it's upwards around 60% class case filings relative to the individual claims. I just think that the plaintiff's bar is becoming extremely specialized. There's the handful of firms that just have created a well-oiled machine, the Kazarunis, the Law HQs, the Kaufmans, Peronich, Perong, et cetera. So these guys have just got the funnel built and they are cranking out class cases. And then the folks who are willing to do it on a professional basis, they know that they can probably get more in those settlements for themselves than if they become a class representative, because that can be a lot of work for them. And the class attorneys just take the overwhelming lion's share of those settlements. So there is that professional plaintiff class. They're around and seemingly doing fine. But the cases are shifting more towards class cases. Obviously, after Facebook in 2021, the ATDS claims are somewhat down. I'm not saying that they're not alleged. There's still ATDS claims alleged. One of them survived the motion for summary judgment this week in the RCI case. So in more favorable forms, and if you're calling strangers, ATDS is probably on the table, but pre-recorded call class cases are hot. DNC claims continue to be a viable place for them. Obviously, it's harder to get a class certified. It should be much harder, if not impossible, in most cases, for a DNC class to get certified for a host of reasons. And then they continue to bundle it with the state claims, like, FITSA, Maryland has a new state law that's very, pro-plaintiff, Oklahoma. So there are states that they're now adding these pending state claims to as well, if only to stack up the damages. So that's the rough lay of the land, and I just don't see that changing. I just see more states going back to a more expansive predictive dialer type definition of auto dialer and enabling those private rights of action and higher statutory damages to continue to incent plaintiffs to do that. I candidly don't think the filing of the claims is really tamping down on the robocalls. I mean, it's been such a steady stream of cases for over a decade now. I think the FCC's enforcement against the carriers is probably what's most moving the needle in terms of robocall volume writ large. Half of my practice is on the carrier UCAS SMS platform side, and the level of government intervention on the carrier side has just been overwhelming since the Trace Act. And so seeing what the carriers are now doing to stem the flow of these types of calls, whether legally or otherwise, or there's just the FCC and the other regulatory bodies have created such a gray area that particularly terminating carriers or the large wholesales can, with labeling, blocking, et cetera, really just, make it a hot mess for legitimate callers to get their calls through. So I don't think the plaintiffs' lawyers are doing anything other than continuing to get rich. And then the carriers are now kind of at the forefront of trying to try to find a safe place to, move minutes and not get your head chopped off.
I mean, has there been any appreciable downturn since the Trace Act in the amount of calls being made? I mean,
the statistics are hard to come by. UMail makes extrapolations, right? There's, obvious incentives for some of that data to be looked at with a grain of salt, but I've seen some suggestions that total volumes are either like increasing at a slower rate or maybe even declining slightly. So the curve seems to be flattening, if it's not declining. But defining robocalls is always tricky. Like, Particularly with the expanding scope of, now it's just unwanted, right? So if the ITG and the regulators just say anything that's unwanted, and we're relying on the subjective perception of the called parties, so I think it's hard to come at real data for a question like that. So it's a very good question. It is the ultimate, $64,000 question. I just don't know that there's ever going to be, perfect data for that.
So there's no official unwanted definition, right?
No, there are real definitions about a telemarketing call, a telephone solicitation, right? But even then, even when there are very specific definitions, right, we still have the ITG and plaintiffs' attorneys suing for, like, for example, there's lots of calls saying, "I'd like to buy your house," right? That is offering to buy something. Well, the definition of telephone solicitation is to sell something. So if antonyms suddenly qualify for the definition, and black also includes white, then if language stops meaning anything, and it's just the question of whether the called party wanted the call, then we're in this kind of lawless world where we're supposed to guess if the people like it and use these analytics based on, whether, calls are declined or carrier decides to block it. And then it just becomes a crowdsourced experience model.
And that's where it gets kind of interesting, because I was at SIPNOC last week in DC, and got a heavy presence from carriers, regulatory enforcement. You got a wide range of people. They're talking about the challenges on the phone line today. And there's a lot of things that Joe touched on that I think are very critical. One thing, and we only spent a few moments on this, but I want to reinforce it for everybody. The plaintiffs bar is bundling state regulations with these lawsuits. That is a big trend. It is a new frontier. And it used to be, 500 to 1,500 per call. Now you're talking about 500 to 5,000 per call, depending on the state law they're bundling in. So it's incredibly important to try to avoid those litigators. Use a litigator scrub. DNC.com has one. A lot of people are using that. Make sure you're following the rules as well, but keep in mind that it has been alleged, and I'm being careful with my words here, that these plaintiffs are getting themselves onto your calling list so that you can call them so that they have a case. The unwanted discussion is quite interesting, because I remember at SIPNOC last year, one of the analytics engines that helps the carriers decide what calls are spam and which ones aren't, and does that blocking and labeling. One of the carriers' analytics representatives said, "Oh, well, it's anytime you get a call that you don't want." So I raised my hand. I said, "Okay, so 75% of the time when my wife calls me, it's a spam call, right? Because, I'm working, I'm busy." And he said, "Oh, I never said on any call you don't want." I said, "No, that was word for word. I wrote it down when you said it." But that's kind of that attitude of the unwanted calls. So, obviously, if you're a caller, you need to be respecting the do not call list. If you have an existing business relationship or there's an inquiry, make sure that the state you're calling into has that exemption. But make sure that you know what you're doing when you're calling these customers. I'm sure we'll touch on this a little bit more later, but make sure you're checking to make sure that's still the phone number that is tied to that consumer when you're calling them. One thing I have seen, and this is data that was talked about last week, was that responsibility being put on the carriers for deciding what's going on. The FTC did a big sweep last year where they were shutting down businesses that were involved with various practices, getting bad consent or illegal consent. The FCC has been going after a lot of carriers, as Joe mentioned, to try to shut them down. I think that's having minimal effect, because realistically what's happening, like there's this his name's Prince Anand, I want to say, who just keeps moving. He's got a bunch of shell companies, he moves those around. You shut down his carrier, well, he'll just find another one. It's really not a big deal for him. I've
One
seen
eye, one ear, one toe, one finger. Yeah.
Exactly. The state AGs actually partnered with the ITG, and they took a big action a year ago, 2 years ago, something like that, going after those auto warranty calls, where there was enough being made that, like, it was an average of every consumer in the country was getting like 2 a day or something like that. It was that bad. So you're also seeing the AGs work together to try to shut those down. And again, this is where it's important to align with a group like ECAC, because the regulators are thinking, okay, how can we make this even more powerful? And one of their big suggestions is, oh, let's use AI to fight AI. Can we have AI listen in on phone calls and use that to determine if those are AI calls, or more dangerously, from an industry perspective, determine if those are unwanted or illegal calls? I don't know how AI can listen to that call and determine that that person opted in, even though they're on the do not call list, or that that pre-recorded call was one the customer wanted from, say, their doctor or pharmacy. So that's something that you have to be aware of and you have to be careful of, because that is out there, and you need groups like ECAC to help keep you up to date with that and be your voice in Washington.
Yeah, you should assume some decent fraction of your calls are hitting one or more honeypots, for sure.
Absolutely.
Actually, Isaac, you started bringing it up. Let's talk about that. About the reassigned database that Maine now has required that. And so, was this, is this to protect consumers, the enterprise callers, or some combination thereof? I mean, what was their motive, and what's going to happen with other states?
Yeah, well, it's funny because with the reassigned number database, it's one of the greatest gifts from regulatory that we have gotten as an industry. Usually, everything we get from the industry is putting more restrictions on good actors when it's doing nothing to stop the bad. But this was a beautiful thing. When the consent rules and all the private right of action, everything bubbled up with the TCPA circa 2015 or whenever it was, my first reaction was, so what? People need consent to get a call. Is that really the worst thing in the world? And the woman who was the CEO of my company at the time said, yeah, but think about it, Isaac. What about when a consumer gets a new phone number? How do you know that that's not their phone number anymore? And it just suddenly, I was like, oh, I had never thought of that. Your consent is tied to both the phone number and the consumer. So when that consumer gives up that phone number, there's no automatic mechanism that lets you know. You can't expect that your consumer is going to reach out to you and say, yes, hey, here's my new number and here's a new consent form. So we had no way as an industry to know that that phone number could no longer legally be contacted. So as good actors, we would often find ourselves calling people that we shouldn't. And in the early days of the TCPA private right of action, you'd read stories like, go Google this, it's in Forbes. You had a woman that carried around a shoebox full of burner phones. And every time she got a call on it, she wrote it down, demand letter, and she made $800,000 a year on that one. So the companies like DNC.com, we came up with our own proprietary product where we were getting data from carriers and all of this, and it's pretty good, but there's now an authoritative list that's sponsored by the FCC. I'm on the oversight committee. I actually had a monthly meeting for that this morning. And it is a database that not only if you use it, you get a safe harbor if you get bad data, but realistically, it's just going to reduce your risk, and it's going to help protect consumers from getting calls that are meant from somebody else. So what does this have to do with Maine? Well, the folks over in Maine at the Public Utility Commission push for this. And I know a couple of gentlemen over there. I had them on a webinar recently. And when they did this, I said to them, hey, I just want to tell you, I appreciate that you've done this because this protects consumers. This protects businesses. Now, the FCC was clear they never really intended for it to be a mandatory requirement, but I saw very little harm in it. And they came back and said, oh, that's not what we're trying to do. We're trying to preserve numbering resources. And I'm not sure how this relates to that. I think that they thought that this somehow would reduce the number of phone numbers being assigned from their state because they have one area code and they're trying to keep it that way. And so I think they were just kind of led down this road that was going to solve a problem that it's not going to. So, they're still working to try to solve the problem with their number depletion. But in the meantime, there's a law that has been passed that if you're calling into Maine and you are not checking the reassigned number database with, prior to making that call, that you are at risk of violating their state calling laws. Now, what gets interesting is you look at states like Florida that back in 2021 passed a bill that had this very problematic language about the automatic selection of records for calling. Forget anything beyond that. Forget dialing, forget any of that, just automatically selects a record. So if I have Salesforce on my screen, it pops up a record and I pick up my phone and I manually type in that number. Since it automatically brought that record to my screen, who cares how I dialed it? That was a violation of state law unless I had consent. Now that has been rolled back since, but since then you saw two other states, Maryland and Oklahoma, adopt that same language. You saw a couple other states like I think it was Michigan and Washington, may have been another, that tried to introduce that language and failed. I think with Maine, there could be an expectation that other states are going to see this and try to adopt that same language, because a lot of them say, oh, hey, that's a good idea. Let's do that too. So, real quick, just to solve your problem, go ahead and start scrubbing for the site number database anyway, because it just lowers your risk.
I love when normally when the Congress or FTC or FCC regulation is always unintended consequences. Here, Maine did something for a completely different reason, and it was a good unintended consequence or intended consequence.
Nobody was shocked to hear that it's not free.
Right. Yes.
Absolutely. Joe, what's the FCC's work? What do you think? What are they looking at now? What's their concerns? They're going to be 2025 and beyond.
Well, on the caller side, it's tightening up prior express written consent, right? That new one-to-one consent rule goes into effect towards the end of January. So everybody, if they haven't already, if you're using written opt-ins to make any type of 227B call, the auto dial call, which you're hopefully not doing, you have real technology, or a pre-recorded or artificial or AI voice, if you're making any of those calls that are of a telemarketing or marketing nature, you've got to be looking at your opt-ins, because we're now down to an opt-in where each consumer is only giving one seller their prior express written consent to make those types of calls. Again, I've heard some rumor that it carries over to 227C for the DNC rules. Those are different rules that I think that's a deep confusion about the structure of the TCPA and what the FCC was trying to accomplish with the one-to-one rule. But if you are making pre-recorded or artificial voice calls, you absolutely need to be looking at the nature of your consents. All of those old forms with the marketing partners that you have to keep scrolling to find your name in, no good, right? Those are dying embers, and they're not going to cut it come January. And then they're also looking again at the AI pieces that we talked about, because they want to get ahead of that. I mean, it doesn't look like they're going to do much more before the election, but the NOI and the NPRM are out there. Comments are due soon. And I think they're hitting it on both fronts. They're hitting it on the caller front, and they're hitting it on the carrier front for sure, right? They had an item on the docket that was removed yesterday about ratcheting up the sanctions and penalties that would be assessed against carriers. So they're active. I mean, this is the number one consumer complaint rule. It is, if there's anything bipartisan in Washington, it is this. So they feel like they have the runway they need to regulate, and they're doing it.
Great to be in an industry where bipartisanship only comes when they're aimed at us, isn't it?
Right. And if I could just touch on something Joe said, because I think this is very important. I agree with Joe's assessment about the DNC list. I think a lot of attorneys agree with Joe's assessment. That doesn't mean the plaintiff's bar isn't going to test it. So you may have to be that first person to fight it in court and decide, am I going to pay the demand letter to make this go away, or am I going to take a stand, or do I have to take a stand because we're not talking a demand letter, we're talking a class action? So this is where it's good to have a discussion, again, with qualified counsel that understands the TCPA, specifically in this case, around the risk. Because even though I, again, completely agree with Joe's assessment, doesn't mean you're not going to have to get that tested in court. I think there's also a lot of debate still about what an ATDS is. And, Joe mentioned this earlier, where the ATDS cases are down. They're not gone, but they're definitely not the primary action that's being brought. And a lot of them aren't surviving. I can't say 100% of them aren't, but, it's definitely not as successful as it used to be. So you need to have a discussion with counsel as well around what, if your platform qualifies as an ATDS, and if your representative feels comfortable defending that position, should they have to in court. There are some that are holding that an ATDS is specifically going to be something that creates random or sequential phone numbers for dialing. There are others that say, well, it also applies to the randomization of phone numbers. And depending on how you view it, I think you could say that there's an argument in both directions, but ultimately, there haven't been. I'm curious to see if that gets tested more post one-to-one, because again, I think they're just going to try a lot of new tactics. So something for you all to keep in mind. With that ATDS topic specifically, there will be a compliance event down in Florida. We'll be talking about that, and that's one of the sessions we're going to have. Is we're going to have differing attorneys debating that very topic of what an ATDS is. I don't know if we'll settle anything, but definitely give you guys something to think about.
They'll keep suing. Yeah.
Yes.
So how about the FTC? So different animal there. I mean, Joe, seeing anything that
They're active. They're active. They're emailing me today, but so the big ticket item, of course, is the new record keeping rules that go into effect next month, right? You've got your 10-item list, things to think about, right? So now, starting in October, so there's a couple of salient points you need to think about. Both the telemarketer and the seller need to clearly delineate who's responsible for all of the new record keeping requirements with the new TSR record keeping rules. I've seen a lot of seller clients who engage various marketers and vice versa, and it's unclear who's going to keep all of these records, whether it's consent, who's calling, what was the script, what was the disposition of the call, et cetera, et cetera. Now, if it is unclear who has to keep the data, the answer is both of you. And because the retention period is now 5 years, some things like call records, carriers only have to keep their CDRs for 18 months. So as a marketer or a seller, now your retention period is 5 years. So you've got to start talking to your carriers about who's going to warehouse the data, where, for how much, et cetera, et cetera. So if you're not already thinking about those record keeping requirements, the clock's ticking. We got a few weeks left, and just get your pencils on the paper about who's doing what for the record keeping requirements for the TSR rules.
And to not lose too much sight of that role association, keep in mind, if you're an outsourcer, if you're a BPO, again, I'm gonna go back to eTech on this. They service some of their customers using platforms that they contract with providers. It's their own technology. There's other times in a BPO, and I've done this personally working for global BPOs, where you're working off of your client system and you may not have the ability to pull that records. So you could find yourself in a position next month where it's not clearly defined as from a responsibility perspective, as Joe said. So then you are required to keep those records, but you lack the ability to get those records. The FTC isn't going to care about that. They're going to say, well, you should have sorted this out. We gave you guys notice. So this is something that you have to make sure is, one, is there a clear understanding of who's going to be complying? And two, are you even capable as a telemarketer to comply?
And the plaintiff's lawyers know this. Like, I already have plaintiff's lawyers putting under my nose, you're supposed to keep these for 5 years. And it is, it's not terribly satisfying to the judge to say, well, that rule doesn't take effect yet. But, this is the evidence to hang yourself. So make sure you know who's supposed to have it. And if you can't have it, make sure your contracts explicitly say who does.
Right. And there's going to be, that's such an important point, because it's all about having that proof that you did what you were supposed to do when you were supposed to do it. I didn't have access, or we didn't think about that, is not a good excuse. You're in the business. You're supposed to know what you are doing. So when it comes to that record keeping, go back to the one-to-one consent. Part of that whole record keeping around that is that if you are the telemarketer, if you're the seller, you have to have that consent record right then and there. If you get called to the table and say, show me that consent record, you have to produce it. If you're asked to show proof that you scrubbed the do not call list, you have to show that you did it, that you had a valid SAN that was authorized to scrub, and that you paid for it. These are all things that now you have to have right away.
Manu, from the perspective of a BPO, that you guys have to do this, going back even to AI, how these technologies, or even if it's not AI, I mean, if it's manual, how are you handling this stuff?
So, Stuart, actually, I was about to kind of talk about this. So, and there is a question in chat, which is a perfect segue into this question as well.
Okay.
Casey is asking, hey, what if I just don't record calls and I don't record any AI conversation? Then am I still, exposed? So let's talk about that, and then, also how we can keep this record keeping, right? So, Casey, if you don't record calls, but still, as Isaac said, if you were supposed to have those documents or recordings, you can, you'll still have to ensure that you are very clear when it comes to contracts. Second thing, let's say you're not recording any of your AI conversation. Now you are completely blind to what your customers are facing when it comes to AI fallbacks. Was AI able to solve all of the issues they had? You don't know. Was there something that AI did wrong on the call? You don't know because you're not keeping even a single record there. So it's always better when it, even when it comes to data minimization approach, don't go nuclear. Don't say I'm not going to store anything at all. What you do is you ensure that you follow right practices. You redact the information, you store them the right way, and then you analyze them accurately. Keeping summaries is almost the same thing. You only have a partial biased view of how the summary was designed, and you would not know much more than that. Coming back to the question of record keeping, as you know, Stuart, you were asking, and how to ensure that you are always compliant. I think the conversation just goes back to having the right documentation discipline and right approach to always ensuring you have those documents in one place. You can always use AI tools to ensure you are organizing them. You can always, as Isaac said earlier, and Joe was talking about this as well, you can always ensure as a BPO, not only are you keeping these records, but you are ensuring that all of these conditions are very clearly outlined in the contracts.
And there are many, many situations where you need to keep the recording. The recording may
Yes.
be the proof of the consent to make a follow-up call, the proof of consent to a transactional term, et cetera, et cetera. So there's lots of times that you need to have the recording.
That actually is the end of the questions that we had prepared for you guys. And there's no other questions in the chat box. Maybe I'll give you each guys a little couple of seconds to summarize. What does 2025 look like? I mean, more of the same, or are we just just going to continue? And then again, a lot of it depends who's going to be at the head of the FTC and FCC and the Supreme Court decision of how those who really owns the right to make these regulations. Casey just put in, but keeping the recording could hurt you way more than not keeping it. I guess that
Casey,
all depends.
And Casey, I think that depends on exactly what your exposure is like, what recording housed, and as Joe was mentioning earlier, if your recordings have consent proof, or so it will depend on a lot of environmental factors. But Stuart, as far as what 2025 entails for AI specifically, can we all imagine that 2023 was when GPT-2 was launched? We are in 2024. We are getting a new model almost every week. There are white papers being written almost every day on new tech that is going in. As the tech is evolving, compliance will evolve as well. So first thing, companies will have to be much more intentional when it comes to compliance management and education. Also, as these requirements and regulatory frameworks evolve, you will have to ensure that you're scaling, especially when it comes to a contact center, and looking at 100% of your conversations when it comes to compliance instead of one single call or one single sample.
Hey, Joe. Yeah, Isaac.
Oh, no, I was just going to say, all these new regulations that are out there, you need to separate that from the plaintiff's bar that are just doing these frivolous lawsuits trying to make a quick buck. The regulators, the people that are creating a lot of these rules, and even the people who are enforcing them, are focused on consumer protection. And by and large, all they're hearing is complaints. They're not hearing anything from the industry. They're not hearing anything from the good actors. And that's why organizations like ECAC are very important, because there needs to be a coalition of good actors in the space that want to respect consumer privacy, but also want to keep their lights on. So they're fine respecting these consumer rights. They're fine following these laws. They're just looking to find that happy medium of respecting customer wishes and being able to reach their audience, especially their audience that wants them. Think about this. 10, 15 years ago, we just got calls from whoever. If you're not on the do not call list, they're getting maybe they bought your lead because they know your income level or where you live, and that's kind of how they're making some loose decisions. These days, things are, at least from the good actors, the leads are much more micro-focused based on your shopping patterns, interests you've shown, forums you've gone to, or websites you've gone to fill out information. So you don't have the day of just the mass spam marketing anymore, at least not at the scale you had before. So if you're a good actor, try to align yourself with a group like ECAC and try to look for standards that go beyond the federal requirements and have a consumer first approach in mind. Show yourself as a good actor and then help be a part of a voice in front of regulators, in front of lawmakers, to show that there are good actors out there in the industry and there is a good use for that industry. And really that's all there is to it.
Yeah. To follow up on Isaac, so when I was the head of government affairs for PACE and then CEO after that, our relationship with the regulatory bodies, especially the FTC, with Laura Groisman and her enforcement group, was they knew that we were trying to do, they knew our members were good actors. They reached out to us for advice. They wanted to know how this would affect, not that they usually agreed with us, but they at least wanted to know what the good actors felt. And so, that's the goal of ECAC. How do we replace that with PACE going out of business? How do we get that where, again, it's not an adversarial position? I'm hoping sometime in 2025, we have a webinar with some consumer advocates. Talk to them. What do they have to say? I mean, a lot of them are unreasonable because they just don't want any calls, period. But how do we work with them to come sensible law? So I do urge you to consider membership with us. The more members, the louder the voice. The more jobs we have. It's still a hot button with legislators. Especially in Congress where they have their congressional district. And we used to target some of those congressional leaders. Based upon where are the contact centers, where are the jobs. And we're going to continue to do that. We just need to get the more members, the louder the voice will be, and it'll be a good customer-centric voice, not an aggressor. Joe, any closing thoughts?
I couldn't agree more. The FCC and FTC need to hear more from the good guys, right? Because all they hear about are problems. And they need to hear about the efforts we're making, the solutions that we can bring to the table, because we do add value, right? This is an important segment of the industry. It adds consumer value. People should be able to use their phones again, right? I see Adam. Adam, thanks for joining us. I see Adam's got a question. Adam, it's not required, but it would be very wise. It future-proofs those opt-ins. So if you include the at least current version of the AI language that's in the FCC's NPRM, look, that could always change. Like the prior express written consent requirements could change, of course. They are not final yet. But if it doesn't add too much meat to your opt-in, it would be wise to include that.
I'm not sure everybody could see that. So his question was, would it be safe to say that all opt-in disclaimers should add AI bid as AI is coming into almost all call center tech that's being used? So
sorry, Adam's asking,
there's no harm.
Should you include it now? And it can't hurt. It may not match whatever the final rule is, but if you're going to use it, it's just another piece of evidence that we're being transparent.
And one more thing. Go ahead, Isaac.
Just really quickly, keep in mind when these new one-to-one rules kick in, it's for any call you make from that period. So if you get consent today and that consent doesn't meet the requirements of one-to-one come January 27th or whenever the new rules come in, that's not a valid opt-in anymore. So yeah, to Joe's point, if you could do it today, it helps better position you for January.
Right. Absolutely. And just one more point, one more thing to add, Adam. Even if you have a consent opt-in, that doesn't mean that everybody downstream can take that information and train their models. So whenever you go ahead and opt for an AI vendor, ensure that you are clearly defining in the contract if your information is used for general model training or not.
Well, there's a couple of questions coming in, and like I said, we'll pose these to our panelists, and when we do the recording, we'll give you some answers. This was a great conversation. you guys did a great job. You guys are subject matter experts, and everyone at ECAC appreciates you being part of as a member partner, but also as a panelist today. So thank you
Thank
for
you.
participating, and we look
It was
forward to
awesome.
reaching out to everybody on that has attended today. Everybody have a great day.
Absolutely. Thank you, Stuart.
Okay, bye.
Thank you so much.